She was just a single mom against the system. When a powerful lawyer tried to humiliate her in court, no one expected what happened next. This is the story of Sarah Martinez, a woman whose courage changed everything. Sarah was 23 years old when her world collapsed. Her husband David had left her for his secretary, taking half their savings and leaving behind only legal papers and broken promises. She found herself alone in a small apartment in Denver, Colorado, with her 3-year-old daughter Emma, who had been born with a rare congenital heart defect called hypoplastic left heart syndrome. The condition was serious. Emma's left ventricle was severely underdeveloped, meaning her heart couldn't pump blood effectively to her body. She needed a series of complex surgeries, the first of which had been scheduled for her 4th birthday. The total cost? Nearly $500,000. When Sarah was married, their family insurance had covered Emma's initial treatments. But after the divorce, David had removed them from his corporate plan. Sarah had scrambled to get individual coverage, but every company she contacted either rejected her application outright or quoted premiums she could never afford on her part-time waitressing salary. Finally, Mountain View Insurance agreed to cover them. The monthly premium took nearly half of Sarah's income, but she paid it gladly. Emma's health was worth any sacrifice. For 6 months, everything seemed stable. Emma had regular checkups, medications were covered, and Sarah began to believe they might actually make it through this nightmare. Then came the letter that changed everything. It arrived on a Tuesday morning in October. Sarah was getting Emma ready for preschool when she noticed the official envelope from Mountain View Insurance. Her hands trembled as she opened it. "Dear Ms. Martinez," it began, "after reviewing your daughter's medical history, we have determined that her cardiac condition constitutes a pre-existing condition that was not properly disclosed at the time of enrollment. Therefore, we are denying coverage for all related treatments, effective immediately." Sarah read the letter 3 times, each reading making her feel sicker. Pre-existing condition? She had disclosed everything. She had filled out every form, answered every question honestly. Emma's condition wasn't a secret, it was documented from birth. She called the insurance company immediately. After being transferred 6 times, she finally reached Linda Hoffman, a claims specialist who spoke in a monotone voice that suggested she'd had this conversation hundreds of times before. "Ma'am, according to our underwriting department, your daughter's condition should have been disclosed differently on your application. Since it wasn't, we cannot provide coverage." "But I did disclose it," Sarah insisted. "I have copies of everything I submitted. I was completely honest about Emma's condition." "I understand your frustration, ma'am, but the decision has been made. If you'd like to appeal, you can submit a written request, but I should warn you that pre-existing condition appeals are rarely successful." Sarah hung up the phone and sat in her kitchen, staring at Emma, who was coloring quietly at the table. Her daughter looked so small, so fragile, yet she faced each day with a smile that could light up the darkest room. How could she tell her that the surgery she needed might not happen? That night, after Emma was asleep, Sarah called her mother in Phoenix. Maria Martinez had raised 5 children as a single mother after her husband died in a construction accident. If anyone would know what to do, it would be her. "Mija," her mother said after listening to the whole story, "these insurance companies, they think they can push around people like us because we don't have money for fancy lawyers. But you know what? Sometimes David beats Goliath. Mom, this isn't a fairy tale. This is real life. Emma needs that surgery, and I don't have $500,000. Then you fight, Sarah. You fight like your daughter's life depends on it, because it does." The next morning, Sarah began her battle. She requested copies of all her application materials from Mountain View Insurance. She visited the pediatric cardiologist, Dr. Elizabeth Chin, who had been treating Emma since birth. Dr. Chin was furious when she heard about the denial. "This is unconscionable," she said, her usually calm demeanor cracking. Emma's condition was fully documented. "I personally submitted letters of medical necessity. There's no way this could be considered non-disclosure." What can I do? Sarah asked. Fight them. And I'll help you however I can. Dr. Chen provided Sarah with copies of all medical records, letters she had sent to the insurance company, and a detailed timeline of Emma's care. She also gave Sarah something else, the contact information for other families who had dealt with similar insurance battles. Over the next 2 weeks, Sarah made dozens of phone calls. She spoke with other parents who had fought insurance denials, with patient advocacy groups, and with social workers who specialized in healthcare access issues. What she discovered made her stomach turn. Mountain View Insurance had a pattern. They specifically targeted single mothers, minorities, and low-income families. They would approve coverage initially, then find reasons to deny claims later, banking on the fact that most people didn't have the resources or knowledge to fight back effectively. Sarah learned about Maria Gonzalez, whose son with cerebral palsy had been denied coverage after Mountain View claimed his condition was pre-existing despite being caused by complications during birth. Maria had given up fighting after 2 years of appeals, and her son never received the therapy he needed. She heard about Jennifer Williams, whose daughter's leukemia treatment was denied because Mountain View claimed there was a family history that hadn't been disclosed, even though Jennifer was adopted and had no knowledge of her biological family's medical history. The more Sarah learned, the angrier she became. This wasn't just about Emma anymore. This was about a system designed to fail the most vulnerable people at their most desperate moments. Sarah began documenting everything. She created spreadsheets tracking similar cases, compiled medical records, and started building what looked like a legal case. She had no formal training, but she had something more powerful, a mother's determination and nothing left to lose. 3 months had passed since the initial denial. Emma's condition was worsening. Dr. Chen warned that they couldn't wait much longer for the surgery. Sarah was running out of time and options. That's when she met Robert Hayes, a retired insurance investigator who now volunteered with a patient advocacy organization. Robert had spent 30 years working inside the insurance industry before becoming disgusted with the practices he witnessed. Sarah, he told her during their first meeting, what you've uncovered here is bigger than just your case. This is systematic fraud. Mountain View is using a strategy called post-claims underwriting. They approve policies knowing they'll find reasons to deny major claims later. Can we prove that? Sarah asked. With enough evidence, yes. But it would require going up against a company that has unlimited legal resources. Are you prepared for that kind of fight? Sarah looked at the photo of Emma on her phone. Her daughter was scheduled for another checkup tomorrow, and Dr. Chen had warned that Emma's oxygen levels were continuing to drop. Mr. Hayes, Sarah said, I'm prepared for whatever it takes. Robert smiled. Then let's get to work. Over the next month, Robert helped Sarah build an ironclad case. They obtained internal emails from Mountain View through Freedom of Information requests related to their government contracts. They interviewed former employees who were willing to testify about the company's discriminatory practices. They documented dozens of similar cases where the company had used identical tactics. What they found was even worse than Sarah had imagined. Mountain View had quotas for claim denials. Employees received bonuses for finding reasons to reject coverage. There were internal memos referring to single mothers as high-risk demographics that should be managed aggressively. One email, sent by Claims Director Patricia Wells, was particularly damning. Focus your denial reviews on single-parent households, particularly mothers. They're less likely to have resources for extended appeals and more likely to accept initial denials as final. Sarah felt sick reading it, but she also felt something else, validation. She wasn't crazy. This was real, documented discrimination, and now she had proof. The question was what to do with it. Sarah couldn't afford a lawyer, and most attorneys wouldn't take a case against a major insurance company without substantial upfront fees. She was stuck with proof of wrongdoing but no way to act on it. That's when Robert suggested something that seemed impossible, representing herself in court. Sarah, you know this case better than any lawyer would. You've lived it, researched it, and documented it. Sometimes the most powerful advocate is the person who has the most to lose. The idea terrified her. Sarah had never even been to court before, let alone argued a legal case. But as she thought about Emma, about all the other families being cheated by Mountain View's system, she realized she had no choice. She filed a pro-Southeast lawsuit representing herself without an attorney against Mountain View Insurance for breach of contract, bad faith denial of coverage, and discriminatory business practices. The filing made local news. "Single mother takes on insurance giant," read the headline in the Denver Post. The story included a photo of Sarah holding Emma, both of them looking determined despite their circumstances. The publicity brought unexpected support. Law students from the University of Denver offered to help with research. Other families who had been denied coverage by Mountain View began reaching out, wanting to join the fight. A local restaurant owner who had read the story arranged for free meals to be delivered to their apartment twice a week. But it also brought attention from Mountain View's legal team. Marcus Webb was a partner at Cromwell, Hayes & Associates, Denver's most prestigious corporate law firm. At 45, he had never lost a case involving insurance claims. His reputation for aggressive tactics and courtroom intimidation was legendary. Insurance companies hired him specifically to make problems like Sarah Martinez disappear. Webb's strategy was always the same: overwhelm the opposition with paperwork, drag out proceedings until they ran out of money or patience, and use his considerable presence to intimidate anyone who dared challenge his corporate clients. When he received the Martinez file, Webb initially dismissed it as routine. Another desperate parent who didn't understand the complexities of insurance law. He expected Sarah to withdraw her lawsuit within a month once she realized what she was up against. But as he reviewed the evidence Sarah had compiled, Webb felt the first stirrings of concern. Her documentation was thorough, her arguments were sound, and her evidence of discriminatory practices was more extensive than he had expected. Still, she was just a waitress with no legal training going up against one of the most powerful law firms in Colorado. Webb had crushed more qualified opponents than Sarah Martinez. The pre-trial motions began immediately. Webb filed motion after motion, attempting to dismiss the case on technical grounds, to exclude evidence, and to limit the scope of Sarah's claims. Each motion required a response, and Sarah found herself spending every free moment in the law library at the University of Denver, learning legal procedure and crafting counterarguments. The law students helped when they could, but ultimately, Sarah was on her own. She was working double shifts at the restaurant to pay for court filing fees and medical expenses, studying legal precedents late into the night, and caring for Emma, whose condition continued to deteriorate. During one particularly difficult week, Emma was hospitalized with complications related to her heart condition. Sarah sat by her daughter's bedside, laptop open, working on legal briefs while Emma slept connected to monitors and oxygen tubes. Dr. Chen found her there at 2 a.m. on a Tuesday night. "Sarah, you need to go home and get some rest. Emma's stable now." "I can't," Sarah said, not looking up from her computer. Webb filed 3 more motions today. "If I don't respond by Friday, he'll get everything dismissed." Dr. Chen sat down beside her. "You know, in my 20 years as a pediatric cardiologist, I've seen a lot of parents fight for their children. But I've never seen anyone fight like you're fighting." "I don't feel like I'm fighting hard enough," Sarah admitted. "Emma needs that surgery, and I'm no closer to getting the coverage approved than I was 6 months ago." "You're wrong about that," Dr. Chen said gently. "Do you know that 3 other families have contacted me in the past month? Families whose children were denied coverage by Mountain View for the same reasons as Emma. They all mentioned your case. They all said you gave them hope that they could fight back too." Sarah finally looked up from her laptop. "Really? Really? What you're doing matters, Sarah. Even if you don't win, though I think you will, you're showing people that they don't have to accept injustice quietly." The next morning, Emma was discharged from the hospital, and Sarah returned to her preparations with renewed energy. The trial was scheduled for January 15th, just 2 months away. Webb continued his attempts to overwhelm Sarah with paperwork and procedural challenges. He scheduled depositions at inconvenient times, demanded extensive document production, and filed motion after motion designed to exhaust her resources and resolve. But Sarah had learned something during her months of research: persistence could overcome resources if applied correctly. For every motion Webb filed, she crafted a precise, well-researched response. When he scheduled depositions during her work hours, she arranged childcare and took unpaid leave. When he demanded documents, she provided them organized, indexed, and cross-referenced. Most importantly, she never let him see her intimidate her. During her deposition, Webb spent 4 hours trying to confuse Sarah about technical insurance language, legal procedures, and medical terminology. He spoke condescendingly, interrupted her answers, and repeatedly suggested that she was in over her head. But Sarah had prepared for this moment. She answered each question clearly and concisely. When Webb tried to twist her words, she calmly corrected him. When he attempted to intimidate her with his aggressive tone, she maintained her composure and stuck to the facts. By the end of the deposition, Webb was visibly frustrated. His usual tactics weren't working on this young woman who refused to be bullied. "Ms. Martinez," he said during a break, "you realize that even if you somehow win this case, Mountain View will appeal. They'll drag this out for years. Can you really afford to keep fighting?" Sarah looked him directly in the eye. "Mr. Webb, can you afford to keep defending practices that deny health care to sick children?" Webb didn't answer. As the trial date approached, Sarah's case began attracting more attention. The Denver Post ran a follow-up story detailing the evidence of discriminatory practices she had uncovered. A local television station interviewed her about the broader implications of insurance companies targeting vulnerable populations. The coverage brought more support. A group of local lawyers offered pro bono assistance with final trial preparations. Medical professionals, including Dr. Chen, volunteered to testify about the importance of Emma's surgery and the medical necessity that Mountain View had denied. But it also intensified pressure from Mountain View. They offered Sarah a settlement, coverage for Emma's surgery plus a small monetary payment in exchange for her agreement not to discuss the case publicly and to drop all discrimination claims. Sarah was tempted. The settlement would get Emma the surgery she desperately needed, and Sarah could stop living in constant stress and financial strain. But as she considered the offer, she thought about all the families she had spoken with during her research. Maria Gonzalez, whose son never got the therapy he needed. Jennifer Williams, whose daughter's cancer treatment was delayed for months while she fought for coverage. The dozens of other families who had given up their fights because they didn't think they had any other choice. Sarah rejected the settlement. "This isn't just about Emma anymore," she told the reporter who had been following her story. "If I take their money and stay quiet, nothing changes. Next month, they'll deny coverage to another family, and that family won't have the evidence I have to fight back." Webb was furious when he learned about Sarah's decision. In his experience, everyone had a price, and single mothers struggling to pay medical bills were usually eager to accept whatever they could get. He increased the pressure, filing emergency motions attempting to delay the trial and exclude key pieces of evidence. But Sarah was ready for each challenge. She had spent months learning the law, and she knew her case better than anyone. The trial began on a cold Monday morning in January. The courthouse was packed with families Sarah had met during her research, law students who had helped with her case, and reporters covering what had become a David versus Goliath story. Emma was in the courtroom too, sitting in the front row next to Sarah's mother, who had driven from Phoenix to provide support. At 4 years old, Emma didn't fully understand what was happening, but she knew it was important. She wore her favorite dress, bright yellow with flowers, and carried a small stuffed heart that Dr. Chen had given her. Judge Patricia Morrison called the court to order. A veteran of 25 years on the bench, Judge Morrison had a reputation for fairness and intolerance for courtroom theatrics. She had reviewed all the pretrial motions and was familiar with both sides' arguments. Webb stood to deliver his opening statement. Dressed in a perfectly tailored navy suit, he exuded confidence as he approached the jury. Ladies and gentlemen, he began, this case is about the complexities of insurance law and the unfortunate reality that not every claim can be approved. Mountain View Insurance is a responsible company that must carefully evaluate coverage decisions to keep premiums affordable for all policyholders. He painted Sarah as a sympathetic but ultimately misguided plaintiff who didn't understand the legal requirements for insurance coverage. He suggested that Emma's condition had been improperly disclosed and that Mountain View had followed standard industry practices in denying the claim. While we all feel compassion for Ms. Martinez and her daughter, Webb concluded, compassion cannot override legal requirements and sound business practices. Mountain View Insurance followed the law, and their decision should be upheld. Then it was Sarah's turn. She had practiced her opening statement dozens of times, but standing in front of the jury, looking at Emma in the front row, the prepared words felt inadequate. Instead, she spoke from her heart. Your Honor, members of the jury, my name is Sarah Martinez, and I'm here not just as a mother fighting for her daughter's life, but as a voice for every family who has been told that their child's health is less important than an insurance company's profit. She walked to the evidence table and picked up a thick folder. This folder contains documentation of 127 cases where Mountain View Insurance used identical tactics to deny coverage to families just like mine. Single mothers. Minorities. Low-income families. People they believed wouldn't fight back. Sarah's voice grew stronger as she continued. Mr. Webb talked about legal requirements and business practices. Let me tell you about the business practice of targeting the most vulnerable families in our community and gambling that they won't have the resources to seek justice. She opened the folder and pulled out one of the internal emails. This is an email from Mountain View's claims director to her staff. Focus your denial reviews on single-parent households, particularly mothers. They're less likely to have resources for extended appeals. The courtroom was silent. Several jury members looked shocked. Your Honor, this case isn't complicated. Mountain View Insurance took my premium payments for months, knowing they intended to deny coverage when my daughter needed surgery. They bet that I would give up when they said no. They were wrong. Sarah's opening statement lasted only 10 minutes, but it was clear she had made an impact. Webb looked uncomfortable, and several jury members were taking extensive notes. The testimony phase began with Dr. Chin, who explained Emma's condition in detail and testified about the medical necessity of the surgery Mountain View had denied. In my professional opinion, Dr. Chin stated, Emma's condition was properly disclosed to Mountain View Insurance. The surgery I recommended is not experimental or optional, it is medically necessary to save her life. Webb's cross-examination of Dr. Chin was aggressive but ineffective. The doctor remained calm and professional, repeatedly emphasizing that Emma's condition had been fully documented from birth and that all appropriate disclosures had been made. Next, Sarah called Robert Hayes, the former insurance investigator who had helped her build her case. Hayes testified about Mountain View's internal practices, walking the jury through company documents that showed systematic targeting of vulnerable populations for claim denials. In my 30 years in the insurance industry, Hayes said, I never saw anything as blatant as what Mountain View was doing. They had quotas for denials. Employees received bonuses for finding reasons to reject claims. It was a factory for creating denials. Webb objected repeatedly during Hayes' testimony, but Judge Morrison allowed most of it, noting that the witness's expertise and access to internal company documents made his testimony highly relevant. The most powerful testimony came from other families who had been victimized by Mountain View's practices. Maria Gonzalez took the stand and described how her son's cerebral palsy treatments were denied using the same pre-existing condition excuse that had been used against Emma. Jennifer Williams testified about her daughter's delayed cancer treatment and the months of fighting she had endured before finally giving up. By the end of the second day, Webb was visibly struggling. His usual confidence was shaken, and his objections were becoming more desperate and less effective. On the third day, it was Mountain View's turn to present their defense. Webb called Patricia Wells, the claims director whose discriminatory emails had become central to Sarah's case. Wells was clearly uncomfortable on the stand. She attempted to explain away the emails as misunderstood internal communications and claimed that Mountain View's denial practices were standard industry procedures. But Sarah's cross-examination was devastating. Ms. Wells, you wrote in this email that single mothers are less likely to have resources for extended appeals. What did you mean by that? Wells stammered. That was taken out of context. What context makes it appropriate to target single mothers for claim denials? We don't target anyone. We review claims based on policy terms. Sarah walked to the evidence table and retrieved another document. Ms. Wells, this is a performance review for one of your claims adjusters. It states that he exceeded denial quotas by 15% this quarter. Can you explain how having quotas for denials serves policyholders' interests? Wells couldn't answer effectively. Her testimony, intended to defend Mountain View's practices, instead reinforced Sarah's arguments about systematic discrimination. Webb called several other Mountain View employees, but their testimony only made things worse. Internal emails and documents that Sarah had obtained painted a clear picture of a company that intentionally targeted vulnerable families for claim denials. On the fourth day, it was time for closing arguments. Webb made a desperate attempt to refocus attention on technical insurance language and legal procedures, arguing that Mountain View had followed the letter of the law even if their internal communications looked bad. Ladies and gentlemen, he said, insurance companies must make difficult decisions every day. We cannot allow emotion to override legal requirements and sound business judgment. But his argument felt hollow after 4 days of testimony about systematic discrimination and deliberate targeting of vulnerable families. Then Sarah stood for her closing argument. Your Honor, members of the jury, 4 days ago Mr. Webb told you this case was about the complexities of insurance law. He was wrong. This case is about right and wrong. It's about whether a company can take premium payments from families like mine while planning to deny coverage when we need it most. She paused and looked at Emma, who was watching intently from the front row. Emma is 4 years old. She doesn't understand insurance law or business practices. She only knows that her heart doesn't work right and that doctors say they can fix it. Mountain View Insurance has decided that Emma's life is less important than their profit margins. Sarah walked toward the jury box. But this case isn't just about Emma. It's about every family represented in this courtroom today. It's about Maria Gonzalez's son, who never got the therapy he needed. It's about Jennifer Williams' daughter, whose cancer treatment was delayed while her family fought for coverage. Her voice grew stronger. Mountain View Insurance bet that families like ours wouldn't fight back. They created a system designed to deny coverage to the most vulnerable people in our community. They were wrong about us, and they're wrong about what's legal. Sarah held up the folder of evidence one more time. The evidence is clear. Mountain View Insurance engaged in systematic discrimination, deliberate bad faith, and breach of contract. They took our money knowing they planned to deny our claims. That's not complex insurance law, that's fraud. She looked directly at the jury. I'm asking you to send a message that families like ours matter. That sick children deserve health care regardless of their parents' income or social status. That insurance companies cannot prey on vulnerable families and call it good business. Sarah returned to her seat, emotionally drained but feeling like she had said everything that needed to be said. The jury deliberated for 6 hours. Sarah spent the time in a small conference room with Emma, trying to stay calm while waiting for the verdict that would determine their future. Finally, the bailiff announced that the jury had reached a decision. The courtroom was packed as everyone filed back in. Emma sat in the front row, holding her stuffed heart, not fully understanding the significance of what was about to happen. Judge Morrison called the court to order. Has the jury reached a verdict? The foreman stood up. We have, Your Honor. In the case of Martinez versus Mountain View Insurance, how do you find? Sarah held her breath. We find in favor of the plaintiff on all counts. We award damages in the amount of $2.3 million for breach of contract, bad faith denial of coverage, and discriminatory business practices. The courtroom erupted. Families who had supported Sarah throughout the trial began crying and applauding. Emma looked confused but smiled when she saw everyone's happy reactions. Webb sat frozen, unable to believe what had just happened. He had never lost a case like this. Never been defeated by a pro-se plaintiff with no legal training. But Sarah wasn't done. She stood and addressed the court one more time. "Your Honor, this victory isn't just mine. It belongs to every family who has been told they don't matter by companies like Mountain View Insurance. I hope this sends a message that ordinary people can fight back against injustice and win." Judge Morrison smiled slightly, a rare display of emotion from the veteran judge. "Ms. Martinez, in 25 years on this bench, I've rarely seen a case argued with more passion and preparation. Your daughter is lucky to have you as her advocate." The verdict made national news. "Single mother defeats insurance giant" headlines appeared in newspapers across the country. Sarah's story inspired other families to fight questionable insurance denials, and several law firms began taking on cases against Mountain View Insurance using Sarah's research and legal strategies. Emma got her surgery 2 weeks later. Dr. Chen performed the procedure at Children's Hospital, and it was completely successful. Emma's recovery was faster than expected, and within a month she was running around like any other healthy 4-year-old. But the impact of Sarah's victory extended far beyond her family. Mountain View Insurance was forced to pay settlements to dozens of families whose claims had been wrongfully denied. The company implemented new policies prohibiting discriminatory denial practices, and several executives, including Patricia Wells, were terminated. Sarah used her settlement money to enroll in law school at the University of Denver. She graduated summa cum laude 3 years later and immediately opened a legal clinic specializing in insurance disputes and patient advocacy. Her clinic, which operates on a sliding fee scale to serve low-income families, has helped hundreds of families fight insurance denials and navigate the complex healthcare system. The wall in her office is covered with thank you letters from families she's helped, and photos of children who received life-saving treatments after their coverage was approved. Emma, now 7 years old, is a healthy, active child who loves soccer and wants to be a doctor when she grows up. She doesn't remember much about the trial, but she understands that her mother fought for her in a way that helped other families too. Webb left corporate law after his defeat and now works for a non-profit organization providing legal services to low-income families. He still practices insurance law, but now he fights for policyholders instead of companies. In a surprising turn of events, he and Sarah occasionally collaborate on cases involving insurance discrimination. Webb's inside knowledge of corporate tactics, combined with Sarah's passion for justice, makes them an effective team. "Sarah taught me something I had forgotten," Webb recently told a reporter. "The law isn't just about procedures and precedents. It's about people. And sometimes the most powerful arguments come from the heart, not law books." Sarah's case established important legal precedents that have made it harder for insurance companies to engage in discriminatory practices. Law schools now use her case as an example of effective pro-se litigation, and her story is taught in courses on healthcare advocacy and civil rights. But perhaps the most important impact of Sarah's fight is the message it sent to other families facing similar battles: you don't have to accept injustice quietly. Sometimes the system fails, but individuals with courage and determination can force it to change. Today, Sarah continues her work at the legal clinic while serving on the board of several patient advocacy organizations. She speaks regularly at conferences about healthcare access and insurance reform, always emphasizing that ordinary people have the power to create extraordinary change. Emma attends a regular elementary school and excels in her studies. Her heart condition is now a distant memory, managed with regular checkups and no longer limiting her activities. She plays soccer, takes piano lessons, and dreams of becoming a pediatric cardiologist like Dr. Chen. When people ask Sarah about her advice for other families facing insurance denials, her answer is always the same. Don't give up. Document everything. Find allies who believe in your cause. And remember that when you fight for your child, you're fighting for all children. That's a fight worth winning, no matter how long it takes or how powerful your opponents seem. Sarah's story proves that sometimes the most unlikely heroes emerge from the most desperate circumstances. A young waitress with no legal training took on a corporate giant and won, not because she was extraordinary, but because she refused to accept that her daughter's life was less valuable than a company's profits. In a world where ordinary people often feel powerless against large institutions, Sarah Martinez showed that courage, preparation, and determination can overcome seemingly impossible odds. Her victory belongs to every parent who has ever fought for their child's future, and to everyone who believes that justice should not depend on wealth or status. The case of Martinez versus Mountain View Insurance changed laws, saved lives, and inspired countless others to fight for what's right. But most importantly, it proved that when a mother fights for her child, she's not just fighting for one family, she's fighting for the principle that every child deserves a chance to live, grow, and dream. And that's a fight that should never end.